This national Capitol building represents legal monism, the belief that everyone living within a nation's borders is governed by a single, unified set of rules. But the legal landscape is bifurcated. Anchored below is lex loci, public law rooted in territory. Floating above is lex contractus, the Lex Mercatoria. It forms a web of private transactional law, a shadow jurisdiction where the elite entirely bypass public courts. By migrating into this secondary legal space, transnational actors shield themselves from national sovereignty. It raises a difficult question. Is your government actually in control, or is a medieval merchant code running the world from behind closed doors? This muddy medieval market square is the birthplace of that shadow system. Traveling merchants moving across fragmented territories face the protectionist and slow-moving justice of local feudal lords, a system incompatible with the fluidity of cross-border trade. To keep capital in motion, merchant guilds engineered their own autonomous legal framework. These fairground rules were designed to operate independently of any king or monarchical authority. The code relied on three pillars. First, the evasion of local feudal reach. Second, speed, resolving disputes while the dust was still on the feet. And third, the prioritization of commercial efficiency over the moral or communal frameworks used in traditional courts. These temporary market rules did not fade away with feudalism. They became the foundational logic for a borderless architecture of power that prioritizes the requirements of the contract over the laws of the land. In these modern blue glass skyscrapers, the Lex Mercatoria has found a permanent home. Over centuries, trade customs evolved into sophisticated corporate statutes that now govern our digital and financial infrastructure. This evolution reached a turning point when private contracts began to supersede constitutional rights. When a person clicks "I agree" on a digital terms of service, or a nation signs a trade treaty, they often waive the right to a public trial in favor of this private jurisdiction, a quiet contractual coup. The engine of this system is private arbitration. Instead of public judges in open court, disputes are settled in closed-loop shadow courts staffed by private lawyers who are not accountable to any electorate. This blueprint shows the three walls of secret justice. First is confidentiality. By excluding the public and the press, precedents remain shielded from scrutiny. Then two more walls drop: no public appeal and extra sovereign independence outside national supreme courts. By privatizing the monopoly on force, using private financial channels to automatically freeze assets or transfer funds, these tribunals have created a judicial black hole. For transnational actors, the public legal system has become a relic. This photo captures the signing of a free trade agreement. Hidden within such documents are investor-state dispute settlement, or ISDS clauses, the most potent manifestation of modern merchant law. These clauses grant corporations the power to sue sovereign nations in private tribunals. If a government passes a law that threatens expected future profits, the corporation can demand billions in compensation from that nation's treasury. You see the tension in this protest. When a nation tries to enact environmental regulations or labor standards, as these people are demanding, they find their democratic mandates challenged by profit-driven courts. This creates a regulatory chill. Faced with the threat of insolvency for massive fines, governments often roll back protections or repeal public interest laws before they are even enacted. The enforcement of ISDS creates a democratic deficit. Society now lives under a corporate crown, where the logic of a private contract can effectively veto the collective choice expressed at the ballot box. As merchant codes are hard-coded into our financial protocols and digital infrastructure, we are seeing the emergence of private cities and digital jurisdictions. In these zones, the elite can opt out of the social contract entirely, living under a modern version of the merchant crown. To preserve the common good, we must demand the disclosure of the secret rules governing our financial lives and advocate for the return of all commercial disputes to transparent public courts. Understanding the lineage of the Lex Mercatoria is the first step in reclaiming the public square. It ensures that justice remains a public right for the many, rather than a private luxury for the few.